Felony.
This is a revocation and he's getting time.
All right, we're on the record in cause number 2410921-20, State versus appears to be Christopher Britton, who is present before the court from the jail by Zoom. Third-degree felony possession of controlled substance, meth. He is present from the jail. His attorney, Mr. Zach Davis, present from his office. Mr. Zach Gilmore, State's Counsel's present from his office. Went away the reading form of presentation of indictment, all the other formalities, Mr. Zach Davis.
Yes, Your Honor, his name set forth correctly.
Mr. Britton, raise your right hand to have to swear you in. You solemnly swear the testimony you will give will be the truth, the whole truth, and nothing but the truth, and in that any of the documents that are show signed and sworn to by you are being sworn to by you now freely, intelligently, knowingly, and voluntarily.
I do.
Okay, do you understand all the allegations and the charge in the indictment and the full range of sentencing?
Yes, sir.
All right, I've got a first thing that's going to go up on the screen is going to be the written plea admonishments and stipulations of evidence, State's Exhibit number 5. Have you been over that with your attorney, Mr. Zach Davis?
Yes, sir.
You understand you're charged with possession of a controlled substance, a third-degree felony, as alleged in the indictment, 1 gram or more, but less than 4 grams, including the adults and dilutants of methamphetamine. Full range of sentencing on the third degree is not less than 2 years and a maximum up to 10 years in TDC, fine of up to $10,000. You understand all that?
Yes, sir.
All right. Looking at your written plea admonishments, which is going up on the screen right there. At the bottom, there's going to be a signature signed, looks like Chris Britton, but I need to ask, is that your signature?
Yes, sir.
Also signed by Mr. Davis. It shows you signed and sworn to the document, which now I've sworn it to you as one of those that indicates it was sworn to. Did you go over this written plea admonishments and stipulations of evidence, Mr. Zach Davis, so you understand it?
Yes, sir.
Now, all right, it's marked as State's Exhibit number 5. And what we actually have here, this is 2410921-20, State versus Christopher Britton on a possession of a controlled substance, meth, a third-degree felony, and then over another cause number, no, same cause number, 2410921-20 is the State's motion to adjudicate. You want to explain this one to me, Mr. Gilmore?
Your Honor, we are here on a motion to adjudicate in 2410921-20. I think the state's ready to proceed. We have an agreement, a recommendation of punishment on this case. I'm not aware of another cause number.
Well, I mean,
I'm sorry.
The written plea admonishments and stipulations of evidence, which have just now been sworn to by the defendant on this 26th day of October 2020 as State's Exhibit 5. And then the motion to adjudicate makes me think the defendant is already on deferred adjudicated probation.
Yes, Your Honor, that is correct. We are here on a revocation. He was placed on 5 years deferred on the 29th day of July 2020, and we are now here to proceed on the state's motion to revoke.
Okay, I see the problem. I see where you are now. Let me get pull out the judgment on the state's motion to adjudicate guilt. There should be a set of plea papers in there. I probably didn't get to them on the plea on this third-degree possession. Okay, thank you. Okay. All right. To just be sure the record's correct, what we've got is in 2410921-20, there was a judgment entered by the court for deferred adjudicated probation, State versus Christopher Scott Britton. That was on the third-degree felony possession of controlled substance. Court taking judicial notice of all the prior proceedings in the cause. the court had followed the state's recommendation in that cause number and entered a judgment withholding a finding of guilt and placing the defendant on deferred adjudicated probation for a period of 5 years. Now the state has filed on this 5 years deferred adjudicated probation, on which the defendant was placed on July the 28th, 2020. Now the state has filed a motion to adjudicate the deferred adjudicated probation on the order of deferred that was entered back on the 29th day of July 2020. So you're ready now on the state's motion to adjudicate, Mr. Davis, now that I'm doing it the right way? I'm sorry, Mr. Gilmore, you ready?
Yes, Your Honor, we are.
All right, you ready, Mr. Davis?
Yes, sir.
All right, now I've already sworn you in, Mr. Britton, but now that I've got it in front of me, I need to ask you, have you gone over the state's motion to adjudicate with your attorney, Mr. Zach Davis, so you understand all the allegations and the charge in the motion to adjudicate?
Yes, sir.
All right, now I have a document that has been signed and shows to have been signed and now sworn to you, sworn by you from under oath from the court, signed by you, and you're we'll get it pulled up where I can be sure it's your signature. Coming on up down the left side, it's going to be where it's signed Ken Britton, and that is, or Chris Britton, that is your signature, correct?
Yes, sir.
It shows you signed, and now I've sworn you to the document. It's signed by your attorney, Mr. Zach Davis. Do you understand the state's motion to adjudicate in this case alleges in the paragraphs set out therein, 6 paragraphs, which allege violations of your deferred adjudicated probation? Do you understand that?
Yes, sir.
Now, if I find the allegations in the state's motion to adjudicate to be true, are you stipulating interpleas of true to the allegations in the state's motion to adjudicate? I would grant the state's motion to adjudicate, finding the allegations true, go back and find you guilty of the offense of possession of a controlled substance, a third-degree felony as alleged in the indictment, and you could receive up to 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand that?
Yes, sir.
All right, the document that's up there right now, I've signed and sworn you to it. Do you understand that in the written plea admonishments at the top of the document, there's 4 admonishments, 1 through 4. Do you understand those?
Yes, sir.
Now, in this document, I've got State's Exhibit 5. It states under 1, you can see it on down there under the fat. On 1, it says that the defendant whose signature appears below and who appears in person before the court in person or by Zoom for the record was originally placed on deferred adjudicated probation in this cause. And 2 says that the allegations, Mr. Davis, 2 says that the allegations set out in paragraphs blank of the state's motion to adjudicate are true. So does that need to be allegations in
That's all, Judge.
all paragraphs?
Yes, sir.
Well, with the consent of you, Mr. Davis, the defendant, and state's counsel, so we don't have to take any more time on it, my court coordinator is putting right in where it reads under 2. Can you see this, Mr. Britton? It now reads that the allegations is set out in paragraph all the paragraphs of the state's motion to adjudicate are true. Is that correct?
Yes, sir.
And all that was just typed in. Do you understand you have signed and sworn to the document, which now includes you swearing to paragraph 2 that the allegations are set out in all the paragraphs of the state's motion to adjudicate are true? Is that correct?
Yes, sir.
All right. Now, the court, having looked at State's Exhibit 5, do you understand State's Exhibit 5 that you've signed and sworn to, signed by Mr. Davis?
Yes.
Now,
Yes,
you
sir.
understand where you stipulate and interpleas of true to the allegations and all the paragraphs of the state's motion to adjudicate. Obviously, I'm going to find the allegations for violations of your deferred adjudicated probation in all 6 paragraphs to be true. I'm going to grant the state's motion to adjudicate, which means I'm going to go back and find you guilty of the offense charged in the indictment, which then means I can sentence you up to 10 years in the Texas Department of Corrections and a fine of up to $10,000. Do you understand all that?
Yes, sir.
Have you been over all of this with Mr. Zach Davis, your attorney?
Yes, sir.
All All right, State's Exhibit 5, the written plea admonishing stipulations of evidence. Now it's been filled in to indicate the court has signed and sworn the defendant to the document. He's signed it. Mr. Zach Davis has signed it. Do you want to offer in State's 5, Mr. Davis?
Your Honor, at this time, the state will offer State's Exhibit
Oh,
5.
sorry about that. I got ahead of myself. State's offering written plea admonishments and stipulations of evidence. I was trying to get around to asking Mr. Davis. Is there any objection, Mr. Davis?
No objection, Judge. Sorry.
All right, State's 5, the written plea admonishes stipulations of evidence submitted into evidence with no objection. The court having admitted into evidence State Exhibit number 5, the state's written plea admonishments and stipulations of evidence signed and now sworn to by the defendant, signed by his attorney, approved by the court. State's 5 is in evidence. The court does grant the state's motion to adjudicate guilt, finding all the allegations therein to be true. In granting the state's motion to adjudicate, the court does find the defendant guilty of the offense charged in the indictment, third-degree felony, possession of a controlled substance as alleged in the indictment. Moving to sentencing.
Your Honor, we have an agreed recommendation before the court. The state's going to recommend 4 years in the Texas Department of Corrections in this revocation.
That's correct, Judge.
All right, is that your understanding of your plea agreement, Mr. Britton? 4 years in TDC with credit for time served?
Yes, sir.
All right, the court does having granted the state's motion to adjudicate guilt, the court does find the defendant guilty of the offense of possession of a controlled substance, third-degree felony as alleged in the indictment. The court follows the agreement and assesses the sentence in the case. Was that 4 years? Was that your guilt?
Yes, Your Honor, 4 years.
Court assesses the sentence following the recommendation in the agreement at 4 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served. Restitution order of the Department of Public Safety lab, amount of $180 for the lab fee analysis. Any legal reason for formal sentencing?
No legal reason, Judge.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense alleged in the indictment, possession of a controlled substance, third-degree felony, follows the agreement, assesses the sentence at 5 years in the Texas Department. Court assesses the sentence at 4 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs ordered paid. Restitutions ordered to the Department of Public Safety in the amount of $108 for the lab fee analysis. You understand, Mr. Britton, you presented to the court a waiver of appeal. Waiver meaning giving up. So are you giving up, waiving your right to appeal in this case?
Yes, sir.
All right. Court receives and accepts the waiver of appeal and formally pronounces sentence at 4 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid, restitutions ordered to the Department of Public Safety lab for a lab fee analysis. Credit for time served, as I've said about 3 times, is granted. Waiver of appeals accepted. Defendant is continued to the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the sentence assessed by the court with credit for time served. Mr. Britton, Mr. Zach Davis has been your court-appointed attorney in this hearing. Are you satisfied with Mr. Zach Davis' legal representation?
Yes, sir.
All right, you'll be continued to the custody of the sheriff until you can be transported to a unit of the Texas Department of Corrections Institutional Division to serve the 4-year sentence assessed with credit for time served, restitution ordered to the Department of Public Safety for the lab fee. Waiver of appeal accepted. Anything else, Mr. Davis?
No, Your Honor. Thank you.
Anything else, Mr. Gilmore?
No, Your Honor.
All right, we're in recess.
Thank you.
Have a seat out there and get somebody to walk you back. Prepare.
All right, we're on the record in cause number 241-1012-20 State versus Nicholas Squire on a charge of burglary of a building, state jail felony as alleged in the indictment. Mr. Gilmore, State's Counsel, is present. Mr. Davis is present representing the defendant. Mr. Davis, you want to waive the formal reading and presentation of the indictment in the case?
Judge, this is This is Mr. Rivera. I think we just got mixed up on who it
Okay.
is.
I've got a file here on Nicholas Squire.
Yes, sir. Last time I checked, he was downtown, I think, so I'm not sure but this is Mr. Rivera if we have it.
Okay, no
That is
problem.
my fault.
Now your mom. Like, peppermint tongues.
There you
Well,
go.
they're good.
I thought we would be doing this one next. Okay, so this one is going to be a plea or deferred.
Let me see what all we got here. Pretty thick stack of documents. Well, let's see, it looks like pre-sentence investigation. Let's see, addendum to the pre-sentence report. Cause number 241-1156-20. Charge assault on a peace officer or a judge. Third-degree felony as alleged in the indictment. Carries a range of sentencing of not less than 2, no more than well, acknowledgement of admonishment says not less than 2 years or more than 20 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. All right, Mr. Rivera, raise your right hand so I can get you sworn in. Just raise your right hand. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, what the court has in this case is a pre-sentence investigation. And then the court also has an addendum to the pre-sentence investigation. The addendum to the pre-sentence investigation report is submitted by the Claims Administration Services of the City of Tyler, affidavit and supporting documentation requesting restitution in the amount of $4,414.49 for expenses incurred to date. That amount to be forwarded to the Claims Administrative Services at the Tyler Police Department. That's from Laura Jerick, G-E-R-I-C-K, the pre-sentence investigation officer. There is an attached affidavit signed and sworn to on or about the 13th day of April 2020, showing that the City of Tyler incurred losses as a result of this offense. Affidavits made by Andrea Burkhead, showing total restitution amount $4,014.49. So the court takes judicial notice of the pre-sentence report and the addendum to the pre-sentence report, which is what contains the restitution amount. The offense charged in the indictment, assault on a peace officer / judge, shows, as I've mentioned, that there's a plea agreement in the case. I believe I've mentioned that there's an agreed punishment recommendation, which is going up on the screen, Mr. Rivera. The agreed punishment recommendation, which is up on the screen, it shows there's another case, DA number 20-0158, which is a misdemeanor charge of resisting. If the court follows the plea agreement, that 20-0185, the resisting arrest, would be taking into consideration in Article 1245, and then the state would decline prosecution of it. Also, as part of the recommendation of the state is recommending deferred adjudicated probation in the amount of 10 years. So the recommendation from the state is 10 years deferred adjudicated probation. credit shown to today is 167 days. Council, I'm gonna have to take about a 10-minute recess for, I don't know how I missed it, but for some reason I have not been through that I can recall this post-sentence investigation.
In which
Hold on
wireless
just a
number?
second. Judge, if I could for just a second, I don't know if the court may not recall this, but we had actually we had called this case before. The court had been through the PSI, and we were about halfway through a plea, and the court, he had pled guilty, he had done, and then the court asked him if he was pleading voluntary. He said no, and I was confused, and I think he was confused. I've since talked to him, and he said, "Well, I was just confused. I didn't know exactly what was being asked of me." But the court's already been through the PSI. If the court wants to take time to go through it, I'm not telling the court not to, obviously, but I was just reminding the court.
Remind me of this also, because I remember that. Are there any holes on this defendant?
Yes, sir. There's an immigration hold on this defendant. And we had been through that, Judge, and the court ultimately decided to. The court was trying to decide what the court was going to do. The court ultimately decided to follow the recommendation, and we began the plea, the last hearing, and we went about halfway through it, and there was a question as to the voluntary nature of the plea, and so the court put that on hold, and we reset the plea so I could talk to him to make sure it was more of an understanding issue as opposed to a voluntary issue on the plea. I've since cleared that up with him, and we're ready to proceed at the court's whenever the court feels comfortable.
All right, give me just a minute, since I believe that all take. I'm not sure how long ago that was. I remember the case now, but
Yes, sir.
normally when I see because I've got a plea agreement here where is there an ICE hold on him?
Yes, sir.
Yes, Your Honor, there is.
I remember it now. So basically, I think I made the record clear last time, but I really hadn't decided what I was going to do. I didn't go forward with the plea last time because I've been down this road many times, and I know what's going to happen, not in this regard to this particular defendant, but with an ICE hold on him, the state's recommending now, and I believe Ms. Anderson was here on the first one, and her recommendation was, I'm sure, the same as it is now, which was 10 deferred. And I believe I made at that time, with an ICE hold on him, we all know what's going to take place. He's going to be taken into the custody. He'll remain in jail. ICE will exercise their hold, and then ICE will deport him. So he's basically being put on, I know I made this clear because I have, at any rate, he'll be put on 10 years deferred adjudicated probation on the recommendation of the state of Texas. And the court doesn't have to follow it. But then he'll be deported. He'll be in jail till the ICE hold warrant is served, and he'll be deported to Mexico. And I'm sure glad to see Marcelo, because I had a case one time, and I asked Marcelo, well, if ICE deports you for being illegally in the country and you go back to Mexico after being deported, what do you have to do to meet the terms of your deferred adjudicated probation? And she said, mail in a letter each month. So that's basically what we're doing. I don't know. I had real concerns about it, and I remember it now because I'm not sure I follow that, but by the same token, apparently that's a matter that has been decided by the district attorney's office, and it was a little bit, it's hard for me to follow because I've seen it in other cases. And then, I mean, if a defendant is deported, he has to send in a letter each month, that's all. So what happens if he doesn't send the letter in? Well, Mr. Gilmore comes in with a motion to adjudicate.
Yes, Your Honor.
And then what happens? Well, the court issues a warrant, obviously.
Yeah.
Okay,
Yes,
so
Your Honor.
now there's an outstanding warrant. The defendant theoretically is in Mexico. That happens to be the country I've understood he was from. And there's a no bond warrant out. But anyway, I have real concerns about this, but after thinking back through it, I suppose those are decisions. Technically, the court can reject any plea offer or any plea agreement, but at any rate, I do know now that I came back and told, I'm sure I told Ms. Anderson, probably told Zach, Mr. Davis, the same thing, that I'd go ahead and follow the plea agreement, although, anyway. So I know now the case we're talking about. I do recall it. All right, did I get Mr. Rivera sworn in?
Your Honor, I don't believe so.
Mr. Rivera, raise your right hand. You solemnly swear the testimony you'll give before the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, Mr. Rivera, I'm going to re-identify these plea documents. They're going to be going up on the screen. Is that your signature on the line above where it says defendant right there down the right side?
Yes, sir.
All right, so you have a plea agreement. If I follow the plea agreement, I'll receive and accept your plea of guilty. Then I follow the state's recommendation, assess your sentence at 10 years, deferred adjudicated probation. You'll remain in jail till ICE picks you up and deports you. But you are on 10 years deferred adjudicated probation. Do you understand that?
Yes, sir.
You understand if some later point, if the state files what's called a motion to adjudicate alleging violations of your deferred adjudicated probation, well, let's just say you don't send in a letter 1 month, since that's basically your condition as long as you're in Mexico. I mean, you understand, then all you've got to do, as I understand, is just mail in a letter each month to meet the terms and conditions of your deferred. Do you understand that?
Yes, sir.
And then if you don't mail in the letter each month, here's what will happen. The state, Mr. Gilmore, one of them will reappear, file a motion to adjudicate because you didn't mail in a letter each month. And then that motion to adjudicate, if, it likely would be without your presence. So the court would grant the motion to adjudicate. In other words, then the court would end up finding violations of your deferred adjudicated probation because you just didn't send simply 1 letter a month into the probation department. And then the court would go back and find you guilty and issue another warrant. You with me?
Yes, sir.
Okay. I figured you probably understood it, but I'm going ahead, and I told Ms. Anderson before I was going to go ahead and go back and follow it. So you understand your recommendation you have for Mr. From the state this time is 10 years deferred adjudicated probation. You understand that?
Yes, sir.
And I'm taking under 1245, the resisting in. I've got an acknowledgement of admonishment. You understand you're waiving your right to a trial by jury? You understand you're giving up your right to a trial by jury?
Yes, sir.
You're waiving giving up your right to confront witnesses. Do you understand that?
Yes, sir.
Going up there now is a stipulation of evidence signed, and I've now sworn you to it. Do you understand that stipulation of evidence signed and sworn to by you is a written judicial confession by you to the allegations and the charge in the indictment?
Yes, sir.
You sign and swear to that stipulation of evidence of your own free will and sign it voluntarily.
Yes, sir.
Then there's agreement to stipulate testimony. There's a form for a waiver of appeal, request for waiver of the pre-sentence, which is approved. And also trial court certification of your rights to appeal, and certification back from you to the court on advice you received from your attorney, Mr. Zach Davis. Do
Yes,
you
sir.
understand all these plea documents?
Yes, sir.
Do you still wish to go forward on your plea of guilty to this third-degree felony indictment, charging you with assault on a peace officer or judge? Obviously, in this case, the allegation is that you intentionally, knowingly, and recklessly caused bodily injury to Andrew Hill, who would be a peace officer, hereinafter style the complainant, by striking the complainant with a hard object and throwing the complainant against a hard object and causing complainant to strike a hard object. And the defendant, you knew that the complainant was a peace officer, and the complainant, the police officer, was lawfully discharging an official duty, namely investigating a theft and arresting the defendant. Do you understand those are the allegations in the indictment?
Sir.
Do you understand those are the allegations in the indictment?
Yes, sir.
All right, I'm going to go through and ask you some questions now. Do you read, write, and understand English? Do you read, write, and understand English?
Yes, sir.
Did you say yes?
Yes.
Okay, because we don't have an interpreter here, so I want to be sure do you understand what the court's saying, what Mr. Davis, your lawyer, is saying, what Mr. Gilmore, State's Counsel, is saying? Do you understand what's being said in these proceedings?
Yes.
Have you consumed any alcoholic beverage in the last 24 hours? Have you had any alcohol to drink in jail?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No.
Have you ever been confined in a mental institution or under psychiatric treatment?
Yes.
When was that?
It was like there's been 7 months.
Oh, I mean, how long ago?
Like 7 months.
About 7 months ago?
Yeah.
Now, I'm not asking you, well, let me just ask this. Are you taking, don't tell me what the medications are, but are you taking medications at this time?
No. No more.
Are you under the care of any type of physician or psychiatrist at this time?
No.
Okay, Mr. Gilmore, you are aware he's been in an institution.
Your Honor, I don't believe that showed up in the PSI. I think this is the first I've heard of that.
Well, actually, I didn't recall it, but I've got it here. I looked through the pre-sentence back at the first plea. So he just told me he had been I believe he said answered the question that yes, he had been in a mental institution some number of months ago. Maybe you need to ask him about that if you want to, Mr. Davis, rather than me question.
He was under psychiatric treatment about 6 or 7 months ago before he was arrested. He's not taking any medication at this time, is my understanding. But he understands the nature of the charges against him, understands the consequences. We've been over everything and talked about everything about the problem of the case.
So,
he is competent.
I don't ask the specifics of the treatment, but you have represented him over a period of time based on all your communications with him and explanations to him and his understanding of these proceedings. You do believe he is competent to proceed, is that correct?
Absolutely, Judge. Yes, sir.
You don't have any evidence of incompetence, do you, Mr. Gilmore?
No, Your Honor, the state does not.
All right, let me be sure I've got this recommendation of the state's 10 years deferred adjudicated probation. The court's taken into consideration pursuant to Article 1245, the DA 20-01858 for resisting. I've got acknowledgement of admonishments. These are all signed and sworn to by you, Mr. Rivera. Mr. Rivera, you understand you're waiving your right to a trial by jury, giving that up?
Yes.
All right, there's a waiver of confrontation with witnesses. The next one you're going to be looking at, Mr. Rivera, is a stipulation of evidence signed and sworn to by you. I've sworn you to it, signed by Mr. Davis, also your attorney. You understand the stipulation of evidence is a written judicial confession under oath by you to all the allegations and the charge in the indictment?
Yes.
Did you sign and swear to this stipulation of evidence stage 2 of your own free will and sign it voluntarily?
Yes, sir.
Got an agreement to stipulate testimony, form for a waiver of appeal, form for a waiver of motion for due trial, request for a waiver of the pre-sentence report, which is approved, the trial court certification of your rights to appeal, showing this is a plea bargain case and you have no right of appeal, and it shows that you have waived your right of appeal, all which is correct according to the plea documents that I have. You have signed and presented, along with Mr. Davis, to the court a waiver of your right to appeal, waiver of your right to file a motion to trial. Last documents, advice that you have received from Mr. Davis. All right, understanding all these plea documents, your plea agreement, the allegations in the indictment, and the full range of sentencing. Do you have any questions for me?
No, sir.
All right, got to ask you some questions now here. They're pretty straightforward for purposes of getting your plea done. Do you read, write, and understand English?
I read.
A what?
Yes, sir.
You do read, write, and understand English?
Yes.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
Like I said, sir, like,
Other than what Mr. Davis has told me,
no.
do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case as well as what you're doing in court today with your attorney, Mr. Davis?
Yes, sir.
Is he competent, Mr. Davis?
Yes, sir.
Any evidence of incompetence, Mr. Gilmore?
No, Your Honor.
Court notes State's counsel signed his consent to approve the waiver of trial by jury. Court approves the waivers of trial by jury. All the other waivers in the case signed by the defendant and signed by his attorney. All right, you understand all the allegations in the indictment, Mr. Rivera, and the charge in the indictment. Do you understand that?
Yes.
You understand your plea agreement. If you plead guilty to this indictment, Mr. Gilmore is recommending your sentence at 10 years deferred adjudicating probation. You understand that?
Yes, sir.
You have any questions for me about anything?
No, sir.
All right, in cause number 241-1156-20, what is your plea today to the indictment charging you with assault on a peace officer, third-degree felony is charged in the indictment? Like, what is your plea? Guilty or not guilty?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason? Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way or promised you anything to get you to plead guilty?
No.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
I don't quite understand that.
Okay, well, I understand you might not get that the first time around. You're not the only one. My first question is, are you pleading guilty to the indictment today as a result of any type of delusion in your mind? A delusion in your mind would be some belief that you have that something is taking place that is not taking place. Example, it would be if I look out there in the courtroom and said, I wonder why President Trump's sitting in my courtroom today. That'd be a delusion. I think it's true, but it's not. You see what I'm saying?
Yes.
So do you have any delusion in your mind that's causing you to plead guilty?
Oh, no.
All right, the court does receive and accept your plea of guilty to the indictment in this case, Mr. Rivera. What do you have, Mr. Gilmore?
Your Honor, the state will offer States Exhibit 1, the signed plea papers, States 2, the signed stipulation of evidence, and States 3, the signed discovery compliance forms.
No objection.
With no objection, States 1, all the plea documents. States 2, the signed and sworn to stipulation of evidence by the defendant signed by his counsel. A written judicial confession under oath by the defendant to the allegations of the charge in the indictment. States 3, approved, admitted into evidence by the court. Court having approved, admitted into evidence, States Exhibits 1, 2, and 3, the court does find that all of these plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court finding the evidence in the record is fully sufficient to support the defendant's plea of guilty to the offense charged in the indictment. The court withholds a finding of guilt as to the defendant. But moving to sentencing, Mr. Gilmore.
The state will offer States Exhibit 4, a digital copy of the discovery in this case, Your Honor.
No objection.
States 4 is admitted into evidence with no objection. Any legal reason for formal sentencing, Mr. Davis?
No, sir.
All right, the court in the case then, based upon the defendant's plea of guilty to the offense of assault on a peace officer, third-degree felony is alleged in the indictment. The evidence presented and admitted into the record. The court does find the evidence in the record on the defendant's plea of guilty to the offense alleged in the indictment is fully sufficient to support the defendant's plea of guilty to the indictment. However, the court does follow the agreed punishment recommendation and the recommendation of the state on sentencing and assesses the sentence at 10 years deferred adjudicated probation, considering the resisting under 20-01858 pursuant to Article 1245. Any legal reason bar formal sentencing?
No, Your Honor.
Finding none, the court formally pronounces the sentence. Court finds the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. Court withholds the finding of guilt, follows the plea agreement, the recommendation of the state, and sets the sentence in the case at 10 years. Deferred adjudicated probation, Marcellum. In addition to the standard conditions, it is a term and condition of his deferred adjudicated probation. Following the plea agreement, there is a term of the deferred adjudicated probation as reflected in the addendum to the pre-sentence investigation. There's an affidavit attached from the Claims Administration Services of the City of Tyler supporting documentation requesting restitution to the city in the amount of $4,414.49. $4,414.49 in expenses incurred by the city in this case, which are obviously reference to the injuries sustained by the officer. All right, the court then does formally pronounce sentence. No reason to bar formal sentencing, is there, Mr. Davis?
No, Your Honor.
Court formally pronounces the sentence having received accept the defense plea of guilty to the offense alleged in the indictment. The court withholds the finding of guilt, follows the plea agreement. The state's recommendation is set to the sentence at 10 years, deferred adjudicated probation on all the standard terms and conditions, including the payment to the City of Tyler pursuant to the restitution report for injuries to the officer in the amount of $4,414.49. That's ordered paid by Ms. Rivera to the City of Tyler for expenses for the city's expenses in caring for the injured officer. You wished, Mr. Davis, are you presenting on behalf of the defendant the waiver of motion for new trial and the waiver of appeal?
Yeah, Your Honor.
Do you understand you've signed and presenting to the court, Mr. Rivera, you're waiving giving up your right to appeal? Do you understand that?
Yes, sir.
Are you waiving giving up your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Court receives and accepts the waiver of appeal, orders to file the paper to the cause. You've been represented by your court-appointed attorney, Mr. Zach Davis. Are you satisfied with Mr. Davis' legal work as your attorney? Are you satisfied with the job Mr. Zach Davis has done representing you as your lawyer?
Yes.
All right. Defendant will be anything else, Mr. Gilmore? Anything else, Mr. Davis?
No, Your Honor, not in this case.
All right, the defendant is ordered continued in the custody of the Sheriff of Smith County until he's taken into the custody of the ICE agency of the United States government, which the court does not have any idea of when that'll be, but he is continued in the custody of the sheriff because there's an ICE hold on him. He'll remain in the custody of the sheriff in jail until the ICE administration, the ICE agency, picks him up to be deported on their ICE hold from the country. That's all up to ICE, but he's going to remain in custody here until ICE exercises its hold and removes him from the jail to deport him to Mexico. Anything else, Mr. Gilmore?
Not on this case, Your Honor.
Anything else, Mr. Davis?
No, sir.
All right, you'll need to decline that resisting, Mr. Gilmore. It's been considered under the plea agreement as a 1245.
Yes, Your Honor, I'll take care of it.
We're in recess. All right, we're on the record in cause number 241-1012-20 State versus Nicholas Squire. Squire, present for the court on the indictment charging the offense of burglary of a building. He is present with his court-appointed attorney, Mr. Zach Davis. Mr. Gilmore represents the state defense before the court. Mr. Squire, raise your right hand so I can swear you in. You solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Square, Mr. Zach Davis is on Zoom along with the state's prosecutor, Mr. Gilmore. Have you been over this burglary of a building indictment with your attorney, Mr. Zach Davis, so you understand all the allegations of the charge in the indictment?
Yes, sir.
You understand the indictment for burglary of a building is a state jail felony that carries a sentencing range of not less than 6 months to more than 2 years in a state jail facility, fined of up to $10,000. You understand that?
Yes, sir.
And you have a recommendation in a plea agreement from the state that if you plead guilty to the indictment for burglary of a building, state jail felony,
Yes, sir.
the state's going to recommend, Mr. Gilmore, 12 months in a state jail facility, which will be assessed with credit for time served. Is that your plea agreement?
Yes, sir.
Is that it, Mr. Davis?
It is, Judge.
Is that your recommendation, Mr. Gilmore?
Yes, it is, Your Honor.
All right, so there's going to be some plea papers going up, Mr. Squire, on the first one on the screen. Your first one's your plea agreement. It's signed by Mr. Chambliss, Nicholas Squire, you, and your attorney, Mr. Davis. Your agreed punishment recommendation is you plead guilty to the burglary of a building, state jail felony indictment. State's going to recommend your sentence at 12 months in a state jail facility. No restitutions indicated is due. Credit for time served would be granted on the sentence. Is that your plea agreement, Mr. Squire?
Yes, sir.
Is that it, Mr. Davis?
It is, Judge.
All right, in addition, is that your recommendation, Mr. Gilmore?
Yes, Your Honor.
In addition, we have the following plea papers, and that is your signature on that document. I easily read it, Nicholas Squire.
Yes, sir.
All right, I've got an acknowledgement of admonishments, gives you 5 explanations. You understand by this waiver of trial by jury, you're waiving, giving up your right to a jury trial and just asking the court to hear the case on your plea of guilty without a jury?
Yes, sir.
There's a waiver of confrontation with witnesses on the plea, which you've now signed and sworn to. Do you understand that document?
Yes, sir.
There's a stipulation of evidence. The next one states 2. Do you understand states 2 signed and the court's sworn you to it now? That stipulation of evidence is a written judicial confession to the offense alleged in the indictment, burglary of a building. Do you understand that, Mr. Squire?
Yes, sir.
Did you sign the stipulation of evidence stage 2 of your own free will and sign and swear to it of your own free will?
Yes, sir.
There's an agreement. The court approves the stipulation of evidence stage 2. The next document that we have in the series is an agreement to stipulate testimonies, a form for a waiver of appeal, and a motion for new trial, request for waiver of pre-sentence, which is approved, trial court certification of your rights to appeal, defendant certification back to the court, form for a advice you've received on your right to appeal, and then that would be all the plea documents, and they're all signed by Nicholas Square. So you went over each one of them with Mr. Zach Davis, your attorney, so you understand all the plea documents. Is that correct?
Yes, sir.
And you understand the allegations, the charge in the indictment, the full range of sentencing, and that your plea agreement is if you plead guilty, Mr. Gilmore is going to recommend your sentence at 12 months in a state jail with credit for time served. You understand that?
Yes, sir.
All right. You still wish to go forward on your plea of guilty to the indictment without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case and what you're doing in court today with your attorney, Mr. Zach Davis?
Yes, sir.
Is he competent, Mr. Davis?
Yes, sir.
Any evidence of incompetence, Mr. Gilmore?
No, Your Honor.
Court notes State's counsel signed his consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed and sworn to by the defendant and his attorney. All right, now, Mr. Squire, you understand the allegations, the charge in the indictment against you, the full range of sentencing, and all your plea papers. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
In cause number 241-1012-20, what is your plea today to the indictment charging you with a burglary of a building, a state jail felony?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you to plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed this offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because of any type of delusion you have in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty. What do you have, Ms. Gilmore?
The state will offer States Exhibit 1, the signed plea papers, States 2, the signed stipulation of evidence, and States 3, the signed discovery compliance forms, Your Honor.
No objection.
With no objection, States 1, all the plea documents, States 2, signed sworn to stipulation of evidence, States 3, discovery compliance. All approved, admitted into evidence of States Exhibits 1, 2, and 3. Court having received and accepted, admitted into evidence States Exhibits 1, 2, and 3. Court having admitted those exhibits into evidence, the court does find the defendant's waiver of his rights, execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court receives and accepts the defendant's plea of guilty, and the court does find the defendant guilty of the offense of burglary of a building, state jail felony, based on his plea of guilty and the evidence submitted into the record. Moving to sentencing.
Your Honor, at this time, the state will offer States Exhibit 4, a digital copy of the discovery.
No objection.
States 4 is admitted into evidence without objection. The court in this case then, based upon the defendant's plea of guilty to the offense of burglary of a building, state jail felony, the evidence presented and admitted into the record by the court, the court does formally pronounce sentence. The court does find the defendant guilty of the offense of burglary of a building, a state jail felony. Counsel follows the plea agreement, the recommendation of the state, assesses the sentence in the case at 12 months. In a state jail facility, no fines assessed, court costs are ordered paid. Any restitution, Mr. Gilmore?
No, Your Honor, I believe all the stuff was recovered in this case.
No restitutions indicated as due. Any legal reason to bar formal sentencing, Mr. Davis?
No, sir.
All right, the court in the case then, based upon the defendant's plea of guilty to the offense alleged in the indictment, burglary of a building, the evidence presented and admitted into the record by the court does find the defendant guilty of the offense of burglary of a building as alleged in the indictment, and the court follows the plea agreement. The recommendation of the state assesses the sentence in the case in 12 months in a state jail facility with credit for time served. Sentence is formally pronounced. Waiver of appeal. Mr. Squire, you understand you filed with the court along with your attorney a waiver of your appeal, meaning giving up your right to appeal and also waiving, giving up your right to file a motion for new trial. Do you understand all that?
Yes, sir.
Those waivers are received and accepted by the court. Mr. Zach Davis has been your court-appointed attorney. You satisfied with with the legal representation provided by Mr. Zach Davis, Mr. Squire?
Yes, sir.
It'll be the order of the court, Mr. Squire, then you'll be content to the custody of the sheriff of Smith County until such time as you can be transported to a state jail facility to serve the 12-month sentence assessed by the court with credit for time served, waiver of appeal accepted. Are you satisfied with the legal representation? I believe you said you were satisfied with the legal representation by Mr. Zach Davis. Is that correct?
Yes, sir.
Anything else, Mr. Davis?
No, Your Honor. That's it.
Anything else, Mr. Gilmore?
No, Your Honor.
All right, we're in recess on this case.
That is it, Judge.
Is that it, Devin?
We're done.
Okay.